Oh, yes. I was looking at this thinking that's a huge panel, but I have only seen. Oh,
I was very.
You know what? I mean, I could probably lower this down if you want. Oh, no.
Nope.
It's not, so
Never mind.
This might be as low as I go.
We've been having trouble with our shorter. Is that the highest that one goes? I can maybe try this one, but oh no, those are the same. That's fine. I'll just be short.
Those are a bit funny.
That's
Because it looks like there's room for it to go down.
Yeah. Guess not. Okay, there we are.
Right.
Perfect. Hopefully that will just stop.
I think it must be
Okay,
turned
great. I think I just turned off the mic.
Oh, fine.
There should be one other person?
Yeah,
Yeah,
I think
people?
so.
Okay.
One other person. I
One?
think. Pardon?
It's just this table.
Yeah, I was trying, but it
can,
doesn't
but-
look like it's turned on. Because I tried to use the button to.
Yeah.
So I'm not sure if there's a button. Trying to figure out how to hack the
What are you looking for? The
power.
There's a way to adjust. There's a way to adjust the tables. So
Oh.
you can move it down a bit.
Yeah.
Oh.
I have to find you
my-
Yeah.
it might. Be something that makes you crawl underneath the table.
Yeah.
And yet. There must be one of those. Are the,
Need an outlet? Is that the idea?
no, people wanted to lower the tables a bit, but I don't.
Tables have some sort of control, but it's not turned on.
Yeah.
Shut off. It's not.
Woody.
It's not plugged in?
Are you the only author showing up here? Okay, we just weren't
It's
sure if we needed
Oh,
more
okay.
speakers.
No, thanks for asking.
It's really not working?
Okay.
No, it's, this one's working.
Maybe if you feel comfortable being in this chair instead, we can maybe move up this table.
Yeah, we are a little bit short, aren't we?
Is it because you're down too low? It's too low. These chairs are not the highest that they're at. Okay.
Yeah,
Fortunately.
but everybody else must have been on the previous panels. Everybody was in these and.
Yes.
It was okay.
Okay, as
I
long as
mean,
you
I
thought
don't
it was okay.
I think there was a moment somebody seems like a child, but I was like, oh, maybe it's just, I don't know, my own perception. But I think that must be why it's the table height.
Okay.
It's all right.
I don't think I can help with this.
All I'm gonna do
Okay.
is go my
Okay.
Oh,
Beautiful.
anything that
yeah.
Great.
is bad, they would.
Oh, did you?
Another
Yeah,
good
yeah,
one.
yeah, it's working.
It's their fault.
Look at
Actually, they wanted
that.
to come.
Yeah, yeah.
Wow.
Amazing.
Great.
Okay, that's
Thank
good.
you.
Now let's see if we can do this one.
You'd like this one as well, yes?
Well,
Might as well.
Oh,
oh, look at that. It's going, it's moving.
You tell me when.
When it's level with the other one. I want to be on the same level as the other people.
oh, the lower.
Thank you so much.
All right, that's great. Thank you.
So short for
Oh,
your colleague over there, but.
You're doing- Where should I sit?
you have to sit next to me now.
Okay,
You came
do
late.
it.
Oh, no,
Let's do it.
like over here.
Yeah.
Yeah. Oh.
All right. Hello, everybody. Hope everyone had a delicious lunch. Maybe even a chance to get some fresh air and sunshine. I don't know. All right. Welcome back. We are now moving into a panel that has combined 3 papers on it that touch on the broader collective theme of AI, artificial intelligence governance. We're very lucky to have 3 panelists, Christina Lee, Jen Rasso, and Woody Hartzog representing 4 people, as well as the great Teresa Scaza, one of Canada's leading voices in this space, as our discussant. So if you can join me in welcoming them, and I'll turn it over to you guys.
Whoops. All right. I guess I hope you can all hear me. So thank you very much to Kristen and the organizers of this conference for the invitation to be here and for all the hard work they put in putting together a really tremendous program. So really been enjoying it so far and looking forward to enjoying it some more, especially once we get to relax after this panel's over. So the way this is going to work, we've got 3 different papers. And all touching on AI governance, but really coming at it from very different angles and approaches. I'm going to introduce each one with a short summary and some comments, and then we're going to open it up to, and then I'll give everybody a chance to respond or to comment, and then we'll open it up for a broader discussion. So, so be aware that there'll be we're hoping to have plenty of time for engagement on these 3 papers. So I'm going to start with, and I'm the one who's chosen the order for these papers, and I'm going to pretend that there's a method to my madness. No, and there is actually this time. And I'm going to start with Jen Rasso and her paper on interoperable AI regulation. And so I kind of see them as Jen's paper really like thinking about the broader idea of interoperability and what it means in the context of AI regulation. And then I'm going to talk about Christina's paper, which is looking at a very specific issue in AI regulation relating to remedies. And then I'm going to talk about Woody's paper. And as I was saying to him this morning, his paper is about AI regulation more broadly and where we need to go with it. And I was saying to him this morning that I found it to be a very passionate paper. So not often you get to say that about law review articles. It's like that they're passionate, but this one's a passionate paper. So in terms of the concept of interoperable AI regulation, I mean, I think the concept of this paper is that the language that policymakers use to frame or discuss issues or problems has an impact on how we understand them and how we choose responses to regulating them. And so Jen in her paper looks at what the interoperability of AI regulation means, and I think both domestically, but also internationally across jurisdictions. And in her paper, she traces the origins of the interoperability concept, looking at the old e-government days, which she points out that we now call digital government, but back in the day we did call it e-government, and the values and ambitions of e-government. And she pursues the meaning of interoperability through other socio-legal and technical literature. One of the questions she asks is how concepts like interoperability and laws themselves serve as what she describes as boundary objects. These objects that lie at the boundaries of different disciplines, different approaches, and that can form the connecting pieces between them. But she also notes how these concepts mean different things to different communities, that interoperability for a computer programmer may be very different from interoperability for a policymaker or for a lawyer, and I think that's probably most certainly the case. And so one of the things she asks is how adopting these concepts in areas like law and policymaking where they're not as where they didn't originate and are not as commonly used, how that shifts the content and function of regulation. She also has a particular interest in looking at the Canadian government's focus on and use of the interoperability concept, which is interesting to me, both because of the use of this language as opposed to the more common legal language of harmonization. I mean, for years, we've talked about harmonizing laws across jurisdictions, and now we're talking about interoperability of laws across jurisdictions. And I think that is definitely an interesting take on this. Jen raises the issue that the use of the term interoperability may be also signaling economic interoperability, not necessarily normative interoperability. And I think that's an interesting intuition in this paper, that part of this goal of interoperability is really to facilitate commerce as opposed to harmonizing laws in more normative ways. Another important insight in this paper is whether the focus on interoperability from an economic perspective, the flow of goods, services, and data across borders, diminishes the importance of working towards a common normative baseline, if that's even possible in this space. In other words, I think she questions, and rightly so, the end goal of interoperability discourse in this space. I have to say, and I've done this on a much less thorough level than Jen has. I mean, I find this approach to looking at language and the meaning of language that's being used in a space, especially borrowed terms, to be quite interesting. And I did something similar with the term agile, although much less thoroughly than Jen has done. But I did find it extremely interesting how we have been talking so much about agile regulation, particularly in the Canadian context, although certainly not exclusively in the Canadian context, with this agility being a value and agile regulation. Of course, the term comes from computer programming and then was adopted in the business context and has since been adopted by governments. And I do find it interesting what these words that are used to describe things, what kind of meaning or weight do they bring with them, and how do they how are they meant to frame what it is that the government is doing? And I think agile regulation, for me, Jen has made interoperability even more interesting for me than it was before, but agile for me was also problematic because I think it was about more than just, needing to respond quickly to technological change. And so, one of the things that this paper has me thinking about is whether some of the interoperability sought in AI regulation is a product of trade law concerns regarding the movement of goods and services. So, for example, reciprocal type arrangements under the Canada-Europe Trade Agreement, and how we can arrange our regulatory framework so that trade in AI goods and services can flow more easily across the border, or whether it's more of the kinds of things, the kind of interoperability, which has more commonly been referred to as harmonization, and even sharing of institutions that we've seen in things in the intellectual property context, like movements towards some harmonization around registration of trademarks at the international level, and even creating kind of joint institutions that can facilitate, or shared institutions that can facilitate trademark registration. And in that context, and you can tell that I have, even though I've been doing mostly privacy and AI regulation for the last 5 years, you can tell that I spent probably too much time thinking about intellectual property in a past life. But I wonder if there's also lessons to be learned from the form versus substance debates that arose over Canada's accession to the Madrid Protocol and the Singapore Treaties in the trademark context, where although the goal of the treaty and the protocol was harmonization of international registration, in other words, everybody keeps their international law and we're just going to harmonize registration, in the Canadian context, that actually generated some very substantive concerns over how this harmonization at that level of just registration was actually having a substantive impact on Canadian law and how we've always approached and thought about trademark law. And so I think, again, in this interoperability stuff, it sounds so simple and so straightforward, but it may come with a normative punch as well. And Jen points out in her paper that interoperability in the e-government context hasn't been a great success. We've seen this very much in the Canadian context. We've not been good at it. COVID gave us a bit of a nudge and a greater impetus towards interoperability, particularly with respect to data, because we found that we just couldn't get good data on COVID at a national level because of the lack of interoperability within our systems, data systems across the country. And at least in some ways, this experience may justify, and it has been used to justify, a push towards greater interoperability, at least on some levels. And I wonder if it may also be used as a lever to push towards greater interoperability in the AI context. And another thing that I think is interesting as a result of that, and you can see, like, people always complain about how AI systems are opaque and you can't figure out where the connections are coming from. I got to tell you, I think my brain invented that. But another connection I would make here is that I find it interesting in that context where we've already learned the lessons of poor interoperability at a domestic level, that we also have much greater focus on international operability in the AI context than we do on domestic interoperability, and I wonder about what that means. And so I will. So terrific, interesting paper, and looking forward to more discussion on it. But I'm going to move on now and talk about Christina's paper, which is called Beyond Algorithmic Disgorgement, Remedying Algorithmic Harms. And this paper looks at how algorithmic disgorgement has emerged in the US as a remedy for algorithmic harms. And after analysis of some of the instances where algorithmic disgorgement has been ordered, beginning in the context of the operations of the Federal Trade Commission, or FTC, in the US, and starting with a couple of cases which I think are really, from a Canadian and possibly European perspective, are classic data protection type situations, the Cambridge Analytica case and the Everalbum case. Christina divides these into two broad categories. One is data-based algorithmic harms, so where the harm is really coming from the problems with how the data was collected or used in that particular case. And there, the remedy seems to be based on concepts of monetary disgorgement or the exclusionary rule, with kind of a flavor of unjust enrichment throughout it all. And then a second category of use-based algorithmic harms, which she suggests are probably based in terms of remedies more on a product recall type approach. And there she talks about, among others, the Rite Aid case in the United States, where a pharmacy widely deployed a facial recognition system, but did it in a highly improper way, where just the implementation of the system and the choices that were made around the system were biased and discriminatory and oppressive. And so in that case, the algorithmic disgorgement remedy was issued against Rite Aid and the developers of the algorithms. And although there's still a strong link to improperly collected data in that case, the harm certainly went beyond the misuse of the data and the algorithms, but it also included those deployment choices. And I think it's really interesting, and Christina, I think you do a good job of kind of raising some of the complexities of a remedy like algorithmic disgorgement in a context where it's not just the algorithm that's the problem there, and perhaps not even principally the algorithm that's the problem there. It's not purely a technological problem for which the disgorgement of the algorithm is a solution. And so that she then develops a framework for determining when algorithmic disgorgement is an appropriate remedy, after providing a thoughtful analysis of why, with the growing complexities in how AI models are developed, often built on foundation models, it may not often be an appropriate remedy in this context. And so one of the things that this paper prompted me to think about is the extent to which remedies are shaped by legal infrastructure. And so what I mean by that is that in context in which there are strong data protection frameworks, for example, remedies that require the destruction of improperly collected data seem to be routine and fairly obvious. At the same time, algorithmic disgorgement for algorithmic harms would typically fall outside the remedial scope of such regimes. And so you wouldn't normally get there. So in a data protection regime like Canada, ordering the destruction of the improperly collected data is that works within the system. It's obvious within the system, but algorithmic disgorgement, you're not going there. And so in the U.S. context, where the FTC has that broader remit and has taken an interest in both data protection issues as unfair trade practices and algorithmic issues as unfair trade practices, I think you see probably a borrowing of the disgorgement of data from the data protection context in the EU, a borrowing and an adapting of that, and then it flows much more seamlessly into the algorithmic context. And I just find that an interesting flow of remedies. And so to me, that suggests that, depending on how you've structured your system and what kind of things you have in place, that can give quite a different shape to how your laws evolve. Christina's paper also prompts us to think about the way in which data is intimately tied to algorithms, to their training and operation. And it's interesting to think about the boundaries of data protection in the context of algorithms. In Canada, right now, we're awaiting a report on the joint investigation of the federal Alberta, BC, and Quebec privacy commissioners on an investigation of OpenAI and into their privacy practices. And I think this is an interesting one, and your paper made me think about this because the earlier Clearview AI case, which was also jointly investigated by the commissioners, was in many ways an easy case for the commissioners. I mean, there you had a company that went out and scraped all of these images from across the internet and then created its massive facial recognition database. And our commissioners found that to be a breach of Canadian data protection law, just as many European commissioners have found it to be a breach of their laws. And our commissioners then, of course, ordered the destruction of the data that was improperly collected from Canadians within their specific jurisdictions. The federal commissioner didn't order anything. That's a whole other story and an interesting thing to unravel. But the three provincial commissioners did order the destruction of that data, and so you can see how that follows and that flows. And the commissioners have also since then talked about how it's improper, at least in the public sector context, for public sector actors to use products built on illegally sourced data, products or services built on illegally sourced data. And so in the OpenAI context, I think this becomes really interesting because you've got that tangling up of the data inside in the training of very complex algorithms when you talk about generative AI. And without a doubt, with OpenAI, you have improperly sourced data, both from a copyright perspective and also from a privacy perspective. And so I'm going to be very interested to see what the commissioners do with that and their argument that you can't use an algorithm built on improperly sourced data. And I think there's some parallels there because I think it's probably not an appropriate conclusion to reach for some of the reasons you point out when you're talking about these large language models that are capable of multiple functions and are very complex. But I don't know if they painted themselves into a corner. So we've been waiting for that investigation report, and it's coming. And like we say in Canada, because we're always anticipating that these things that get started are going to get finished. We're going to say it's coming soon, just like we used to say AI legislation was coming soon and other things were coming soon, and none of them come anyway. It's coming soon. So I see a time sign, which I'm also going to play fast and loose with a little bit because I have to talk about Woody's paper. Yeah, sorry, and it's a paper written by Jordan Francis, Woody Hartzog, Ryan Dury, and Neil Richards. And it's a paper which is really a call to action for AI regulation in the United States. As I mentioned, it's a very passionate paper, and it frames the dominant industry-led approaches to AI governance as risk identification and mitigation, as well as transparency. It frames these dominant industry-led approaches to AI governance being risk identification, mitigation, transparency, as half measures that it's not adequate, it's not enough, that we shouldn't be satisfied with that. And the authors define in the paper half measures as, and I quote, an action or policy that is not forceful or decisive enough to respond to the individual and collective risks of AI systems. I would note that, and we have all seen this, how industry counters with over-regulation as what, and I'll paraphrase a definition from them, as an action or policy that is too forceful and too decisive to enable innovation and now I've put in brackets since January 20th, and to facilitate global AI dominance. Sorry. But, and so, I mean, and I think those are the tensions that we're dealing with, and we're fairly aware that we're dealing with. And so the authors of this paper describe audits, conformity assessments, and so on as, and I love this term, managerial box checking exercises that largely serve to entrench harmful surveillance-based business models. And I think that, and I like that language because I think it's very appropriate. I think it's also something that we have to be very attentive to, right? It's very easy to create these frameworks and principles and all of this sort of stuff, and then to have them turn into essentially these box checking exercises. In the Canadian context, at the federal level, we have, I think, a maturing and quite good directive on automated decision making, which is meant to work with an algorithmic impact assessment tool, which is, again, maturing and evolving tool. And those algorithmic impact assessments are meant to be open, published on our open government website so that anyone can go and have a look at them, which I do, because I'm a nerd. And some of them are thoughtfully done, but some of them are really just these box checking exercises. Somebody was told, well, you got to do this AIA, and and you look at them and you think, wow, that's actually not very satisfying. And so I think that we have to be really careful about the extent to which we build into these governance frameworks, all of these things which can be useful and important on one level, but without the oversight and accountability, which you talk about in your paper, without somebody looking over the shoulder and saying, you did not do a good job on this, you need to go back and do it again, then we're not going to get an appropriate level of AI governance. And so the other half for the authors is, of course, accountability and enforcement, as well as the courage to draw hard lines around what is and what is not acceptable. And I think that we see this, we've seen this distinction quite explicitly in Canada with the now defunct AI and Data Act, which was very much focused on ex-ante regulation, but which had none of that oversight, enforcement, accountability in it. In fact, we were told that already all those ex-post things already existed and were out there in the form of, you can complain to the Privacy Commissioner, you can go to the Human Rights Commission, you can do all of these different things, but none of those were ready for, adapted to, suitable for, integrated with AI governance, and I think that that's a problem. Now, one of the things, and I'm just going to flag this because I think it's an interesting question in both of our countries. I think in the Canadian context, some of this shyness maybe around ex post recourse and enforcement, some of it is rooted in our federal system, where there's not everything can be done by the federal government for constitutional reasons, and which leads to things that look like gaps and they are gaps, but they're gaps of a kind of that are rooted in the structural design of our federal system. And I have long thought that kind of AI regulation becomes much more challenging in federal states. And I think we see federal states actually moving much more slowly and chaotically on AI regulation, which on some levels could be a good thing. And in some ways it perhaps is a good thing. Because you can see many different models emerging in different states, for example, or different approaches, and you can build on that richness. But it's also a challenge if you want to move quickly and put something strongly in place that has global impact. So I just flag that as something as something I'd be interested in hearing more about it, whether it's a federalism problem and what we do about that. There's also, of course, and part of this makes me think of Anu Bradford in her book Digital Empires, and just the fundamentally different approaches of digital empires. And you know, she describes the EU as a digital empire which puts fundamental human rights first, and that is very much reflected in the EU approach to AI regulation. And if you take that approach to EU AI regulation, and you're putting fundamental rights first, then I think you're going to have more of an emphasis on accountability and oversight, because that I think very much comes with that territory. Whereas if you put innovation first, then you're going to want less oversight and accountability, and it's almost you know, it almost comes down to that, you know, vision of what AI is in the context of any particular empire. Putting fundamental human rights first also makes it easier to have no-go zones and hard stops, which are some of the things that you talk about. And so in the North American context, then the question is, how do we deal with this? And I would say before our very ugly breakup with the United States, and it's still a very tender topic, we were really struggling to sort of between the U.S. position and the EU position, and you know, how do we do AI regulation? And I think the AI and Data Act was very much a product of us trying to straddle these two digital empires very ineffectively, I would say. But anyway, but post breakup, it'll be interesting to see whether we, as a nation, decide that we're going to have a big rebound relationship with the EU and go to a more rights-oriented approach. So that will be interesting to watch. And so the authors critique transparency as being insufficient on its own, needing substantive legal rights into which transparency feeds. They also flag, of course, that transparency is a concept that means different things to different people. They talk about how incremental technical improvement is also a half measure, giving the example of bias mitigation and privacy enhancing technologies. And again, not to knock either one of those, but they're insufficient. And of course, if you think about the Rite Aid example that we talked about earlier, I mean, bias mitigation with respect to the algorithm doesn't solve the problem when the facial recognition technology system is being deployed in ways that are, even if the algorithm was perfect, are discriminatory towards certain populations and oppressive towards certain populations. And so it only gets you so far. The authors also are critical of self-imposed standards that don't bring with them much accountability. And of course, they're also critical of the approach that empowers individuals and gives them more control, because, you know, how did that work for us with privacy? Don't need to say much more about that. And so they call for some substantive measures in this paper, including duties of loyalty, care, and confidentiality to address some of the privacy issues, design rules, bright line prohibitions, structural and ex-ante approaches, and private causes of action. And they also call for putting the human back into the AI context, looking at human choices and human motivations for which there should be human accountability. And it's so that the focus just on the technology and the algorithms, that it has to be broader than that. And as I said, it's a passionate appeal for action. And one of the questions I would have for you is, what does the paper read like what would the paper read like if it had been written after January 20th, and instead of before? So I'm going to shut up now and invite the authors to comment, respond, and maybe we'll start with you, Jen.
This mic and see how that works. Thanks so much, Teresa, for this really rich set of comments. I guess the one thing, maybe the one thing I would say, as the paper is very much still kind of a work in progress and the earliest statement of my thinking through how interoperability functions in the space of legislative action. And by that, I mean, like, what is interoperability doing in the descriptions by legislatures of regulating AI? Like, how is it changing the way they're thinking about what they do, and how is it changing how law functions in these spaces, I guess. And it would add on to your comments about, interoperability could lead us to have a regulatory form that facilitates trade and economic relations, innovation, and so on. But I wonder, especially with the collapse of the AI and Data Act, or the kind of dying of it as it's described in Canadian legislative process, whether interoperability is living on in what we see happening with how government administration is operating. So part of the paper, I talk about how interoperability is something that folks who've been focusing on digital borders see, and how they're thinking through what border technology is doing. And that, of course, is connected to how interoperability has developed in, I think, the tech space and in the design of border systems. But I wonder if, in the absence of legislation, interoperability exists nonetheless in the way that these other types of government ordering function. So in other words, one of the things that I'm thinking of in trying to tie the paper together is that when we're thinking about what law is and how law operates in the spaces of AI regulation, I think an important landing place that I've reached now is that law is still operating, but it's operating through different forms. So interoperability is still out there, but it's out there in the digital infrastructures that also are governing as importantly as a statute might have, even though the statute didn't get passed in the first place. So I think that that's something that's where I think I want to go with things, in addition to like the piece about economic regulation as well. It's really tricky, of course, because the AI and Data Act was trying to do so many things, which made the interoperability, like the mention of interoperability and the discussion of it in the standing committee debates, really interesting, because it started out as a legislation that was really focused on economics and driven by economics. And then there was a lot of critique about needing to also think about how government uses tech and to what degree it should apply there. And then, so I think that it becomes difficult to untangle what interoperability, kind of the life it's had in those debates, but also how it lives on. So yeah, I wanted to add that as an additional piece that I'm thinking through. And I think it's really useful to hold that up together with the economic kind of economic and trade way of thinking about interoperability as well. Yeah, I'll leave it there because I'm sure there's lots of questions and comments.
Thank you.
Great. Thank you so much for your thoughtful comments. And like, frankly, I'm really more interested in hearing about everyone else's papers because they're also brilliant and interesting. So I'll keep my comments really, really short. I just want to touch on one thing that you mentioned about how remedies might be shaped by legal infrastructure. And I think that's such an interesting point and like an important point. And like, as you mentioned, like in like European data protection context or in Canada, data protection is like such a defined thing, right? So like, okay, like you violate these data protection mandates and then like now you have to delete your data. That's like very natural. But in the US, I think part of the reason why algorithmic disgorgement could develop the way it did is because it like FTC is like the de facto privacy regulator, but like their mandate is really about consumer protection, not privacy, qua privacy, right? So like as such, they could pull from like there are other lines of how they've remedied certain harms, and that's kind of how algorithmic disgorgement came to be. But I think that's really interesting. And I think what's also really interesting that like, it kind of goes into reverse as well, right? So, but now that the FTC has used algorithmic disgorgement as kind of a data protection remedy, now European Union, I think end of 2024 in an EDPB in an advisory opinion said, okay, like if companies train a model with like data that's illicitly collected, algorithmic disgorgement might be on the table, but that came at the end of 2024. And my native country, South Korea, recently used algorithmic disgorgement for the first time as well. South Korea also has a very defined data protection regime. So I think it's really interesting how it goes both ways, where like because FTC has like this broader mandate, they can kind of do things that like very well-defined data protection regimes might not necessarily think to do at first. But now that that's on the table, data protection regimes can now go look at that and be like, oh, that's actually a good idea. We can use that in data protection context as well. And I think that interplay is super interesting. I really want to hear about everyone else's questions as well. So I'll leave it at that for now.
Excellent. Thank you for that great feedback. I really appreciate it. And I'll be brief as well. I'll start with your last question, which is how would this paper change if it were written today? And I think that I'd probably be even more pissed off than I was when I originally wrote the paper. And it only furthers my commitment to the idea that Silicon Valley has a completely impoverished view of humanity, that they're using AI to instantiate, but now it's also clear that some governments also have a completely impoverished view of humanity, and that they are going to use AI as a tool to destroy institutions, and that in fact is its principal purpose. And so I would change my attention to the states if I were doing that. I don't know why I ever thought that Congress was going to do anything meaningful about AI, but I would probably change my focus there. And finally, I'll just say that if an outcome of the messy breakup, as you put it, is that Canada moves closer towards EU-style data protection and human rights commitments, then at least something good will have come. And I'll look forward to everyone's comments.
All right. Well, with that, I'll invite people to come down to the microphones.
Mental. Yay. First of all, great papers, everybody. Really enjoyed them. I have feedback for Jen about and I'm on the wrong page of this, about interop and origin stories. And I think telling this particular origin story might be helpful in kind of bridging the gap between the technical and legal policy. In 2000 or 2001, when the Time Warner AOL merger, one of the conditions that the FCC imposed on the letting the merger go forward was interoperability for AIM, AOL Instant Messenger. And they didn't do that like randomly or out of the blue. It was an incredibly frustrating experience for other purveyors of messenger technology trying to AIM had a really big base of people, of course, in AOL's walled garden, which AOL was very protective and you could say anti-competitive about having access to, they would break the access in, I don't know if they broke an API or what they did, like almost on a daily basis to prevent other messengers. When meanwhile, it's like, the beginnings of social media, like that's what drew people to MySpace. They wanted to talk to their friends. Facebook, same thing, and so on. And I think that it's an interesting example of technical measures, policy, law kind of coming together. So I think that could be an interesting kind of bridge for your paper. Other than that, Teresa, you stole my thunder on Woody's paper. I had feedback from my cat, who's my current meownager. Sue Gluck, Microsoft, currently working for my cat. Sorry, I think I forgot to say that at the beginning. She wanted me to read to you because she likes this reading your paper back to you. Lawmakers, page 42, lawmakers should fund existing agencies and empower them to hire technologists and better enforce regulations within their existing expertise. But there is a potential role to play for an expert meta agency to provide expertise and coordination amongst government actors. Discussion of funding regulators on page 44, funding them adequately to enforce consumer protection and privacy rules. Tatters did not find that to be meowvelous. I hate to tell you. She said, dude, it's 2025. Cats aren't running the government. Dogs are. I think she meant Doge. So I would urge you to consider, the praise of Lena Khan and it's making a great paper seem a little dated unnecessarily. So
Well taken. Thank you.
I'll let her know. Thank you.
I'm Claire Huntington from Columbia Law School, and thank you for all three of these papers. They were super interesting. And I've really already shared these comments with Woody during the break, but I thought I'd share them to the larger group just in case they spark thoughts. So my area, I'm going to talk next on the next panel. My area is family law, really not law and technology. So I come to this with a family law perspective. And I thought the paper would do well to distinguish, because I think you are interested in both, but it should separate and then discuss distinctly harm to relationships and harm from relationships. So here, I think you are interested in the harm to human relationships. That's only one aspect of what you're concerned, but that is one of your concerns. But then your tool and your sort of intervention is really about the harm from relationships. And here it's the relationship between the human user and the technology company. And I think disaggregating those is going to be helpful, and then also situate your intervention, which is about that relationship between the human and the AI company. And then the solution, the proposed solution, is something like a duty of loyalty. And you give us this proposed legislation. And again, I want to put on my family law hat and just say, whenever I hear best interests, like lots of red flags go off. And that's not to say there's a great alternative. So if I'm always interested in that as compared to what question, I'm not sure I have a better a better solution, but at least to be aware of the downsides of the best interest. So two big ones that we always talk about is one, how indeterminate it is. And then a related concern is who's then applying this best interest analysis, like best interest in the eyes of whom, in the eyes of a government, sort of who's to say. And at least because in the family law context, it's really only used in the context of children, where there is at least at a high level of generality, pretty strong consensus that's very empirically based about what is in children's interests, like a strong attachment figure and access to basic resources and those kinds of things. Whereas at the adult level, I think we could imagine, again, if we abstract at a very high level, there are basic needs that all humans have that are also relationship based, but other things as well. But once you get any more fine grained, it would make me really nervous to have something that's about a best interest analysis of what adults need. So. But I'm super intrigued by this paper, so thank you.
Thank you. Can I respond?
Oh, sure,
really quickly? Thank you. So I really appreciate that. And your point about harm to human relationships and harm from relationships with technology is well taken. That's exactly what we're trying to do. And we should be more explicit about the fact that we don't think about our relationship with tech companies as a relationship. It seems weird, right? And a lot of people have criticized us for making that argument, but there's no relationship in the world that's as intimate or as vulnerable as the one that we have with tech companies, based on frequency, based on the amount of exposure we have, based on a lot of the standard metrics in which we would ascribe to relationships. And so we'll be clear about that. And then I really hear you, and we'll probably just reflect this back at you for your paper, thinking about where best interests emerges. So one of the things that we've tried to do is propose a system that has a best interests as the guidepost for a duty of loyalty, as a catch-all that exists on the extreme fringes, but actually with the middle dumping it off onto regulatory rulemaking, with to limit the indeterminacy of it in a way that we say if it falls within one of these sort of 5 areas, and I'm happy to talk with you afterwards, then there's not much room for interpretation, and only in the far extremes would we say, if it falls outside of that, do we then look to a sort of vague sort of best interest standard? So, because I agree with you, it makes me nervous as well, based on who's making the decision.
Yeah,
So,
great, thank
thank you.
Go ahead.
Hi, Michael from the Robotics and AI Law Society. I read, first I want to say about Woody's and Christina's paper. I read first Woody's paper and I found it a really nice pitch to regulators, kind of to, I think many people should read that who are working legislation. I read it also, this is a bit the target group, where I liked it to simplify it and put it to the point, because like the super complicated academic arguments is not what they need. So I really like that. And I also like this idea of the duty of data loyalty that you constructed. And interesting with Christina, kind of look more into the AI value chain. And I think these thoughts that Christina shows there would be very interesting to also integrate in Woody's paper, because I was thinking, you know, this loyalty scheme is like more like a two-party, like between 2 parties. And in AI, we have like so many actors, like third parties, people who give their data. So I was like thinking, did he, you know, is it too undercomplex to think it, you know, just take it from this, I think, fiduciary law. I learned this word new. And then I read Christina's paper and was like, oh, that's very interesting, because she's looking at this value chain. So I think this really complements each other. So you can really learn from each other, I think, there. But then Christina, when I saw yours, is at some point you suggest that, you know, it should be appropriate. Like you bring this appropriate, and then you say we need to consider the facts of the AI value chain. And if it's like a lot of people and it's like, you know, then we should sometimes say it's inappropriate to now delete the data. And in this point, I had the feeling that it might be too factual. You know, it's, I mean, I see it from the EU AI Act. Sometimes we create loopholes if we too much look at how, you know, companies are constructing their models. So I'm just thinking, that was just a question that came up, is what is the consequences if you build up your normative results on basically the facts of how this business model is created? And is there any loopholes coming out of this, and like giving incentives even to companies to just make it really complicated and then nobody has to do it? Is it like a problem maybe even for open source producers? We had this interesting paper today. Like, is it a problem for open source because you never know who uses which component and how they combine it, and how would you even find out about it? So this was something that might be of interest for you. And just one thing, you talk about one part about the remedies in EU AI Act, just the specifics of this is done in the national implementation in the member states, because the remedies is just very abstract in the AI Act, and then it's always has to be implemented very specific. So it would maybe make sense, and there's some drafts already of some member states, to check into that, how they actually translate it in the national legislation, if the data deletion means also model deletion or not. Sorry, and lastly, just Jen, I just wanted to point you in 2 directions, because I've been thinking about this interoperability problem also a lot. And one is like international frameworks could be of interest for you, like the G7 Code of Conduct for GPAI, the UN AI governance report, and also the Council of Europe's position and the OECD position. I mean, this is more harmonization, as you called it. And then really interoperability, what could be interesting for you is the harmonized standards in the European AI Act. You touch on standardization. And I've myself written a paper once where I suggest we shouldn't try to harmonize all these digital and data laws, on the law level, but maybe we can systemize it from below. In fact, if they all use the same technical standards, because all the frameworks are similar, then actually this is real interoperability, because they still use the same ISO, EN standards. So the way of harmonization, there's a lot of literature about this in the EU AI Act. So maybe this can help you. Thank you.
All right, thank you. There's a lot there. Does anyone want to respond?
Yeah, just real fast. Yeah, I completely agree with you that like is a two-fact specific. That's definitely the concern I have as well. I think my response for that would be that, you know, like I haven't solved the whole problem in this paper for sure. But like I think that like I just want to make sure that like we should at least be aware of this problem, that we're gonna have all these impact on all these different actors, and we should like at least be cognizant of that, and then like take that into account as we decide whether certain things are like certain remedies are appropriate or not. Yeah, I acknowledge in the paper as well that it's a hard question. A lot of times you're not always going to know exactly who is impacted, but I think that doesn't mean that we shouldn't try to figure out as to the best of our abilities who all are impacted before we decide to go forward with a remedy or not, because like remedies affect people's like, you know, people's positions and people's rights. So I feel like that's just like something we need to be cognizant of. And even if we can't do it perfectly, we should try to do like as much as possible there.
Yeah, thanks so much for that comment, and reflecting on the kind of harmonization example and Teresa's earlier comments about harmonization. I think this is useful for me in part because interoperability as a concept is a little bit different, and it does slightly different things, which I think is, I think I'll have to tease that out a bit more. And this is something that the folks who developed thinking on boundary objects pointed to as well, that harmonization, you're trying to have kind of a meeting of the minds and creating standards that have some sort of kind of normative coherence across jurisdictions, like no matter what your domestic situation, that there's a system that can be workable for all. And interoperability is slightly different because the intention is that there should be some normative harmony, but there also should be a certain type of modularity so that when something goes wrong, you can kind of pull a piece out without affecting the whole and then slot something new in. And I think that that's something I could better articulate and think through, because I think what's happening with interoperability language, whether it's in the context of digital government or legislation, is a little bit different and leads to slightly different places than harmonization. But yeah, I'm really appreciative of these resources in particular, and it's going to have me thinking, I think, in new directions. Thanks so much.
Thank you so much for that. I really appreciate your feedback there. And I just wanted to say that this has been a sort of ongoing debate around the idea of a duty of data loyalty. And a lot of people highlight the fact that it's limited by relationships. In fact, that it's not universally applicable. It's only that which someone voluntarily chooses to create a relationship with someone when it really binds someone under the theory of that. And we get a lot of pushback that says that, well, a human rights approach is much better, which is hard to argue with, except that the world's going to have to be made over before the US in particular adopts a human rights approach, right? It's just not going to happen. And so we sort of work with the tools that we got, and there actually is a lot of really rich literature and bodies of theory and work coming out around, for lack of a better term, what I'll call team trust. Building out on some of those relational approaches, and I would include Claire's approach to family law and Chinny's work on professionalization as part of that. That actually builds the tools that we do have that could at least get us close to the sort of value commitments that are otherwise, you know, at the starting point of human rights law.
Go ahead.
Hi, I'm Emily McReynolds, once of the University of Washington Tech's Policy Lab. Now a senior fellow at Future of Privacy Forum. And I've done what I call a tour of tech companies. So I've done AI governance at Microsoft, Meta, and Adobe.
And I give that background for these comments. One, I loved your papers, all of them. I've been really enjoying the threads on disgorgement. I think it's a really important consideration. And interoperability, if only. And if only we weren't also looking at something, I forget who brought it up today, but the cultural context, because we've all had many conversations about how GDPR outsourced a certain perspective on regulation and human rights to other parts of the world that didn't apply. So I think that's a really big challenge. I want to point you to a paper. There's something called the Clear Documentation Framework, and it talks about those trade-offs that you've highlighted. It was written with most of the people who wrote AI documentation artifacts in the last 7 years. So Meg Mitchell and Michael Hind, AI fact sheets, model cards, data cards, all those people. It was published through the Shorenstein Center, so you can find it. Woody, I have lived your anger for 6 years. The burnout of actually trying to do this stuff is pretty spectacular. So I really appreciated the half measures perspective. I like that we come up and say, have you read? So there's actually a whole literature on these topics in HCI. If you look at Chi or FACT, you have papers from a huge crew of people who work, both industry researchers from like Microsoft Research, IBM Research, actually investigating their own companies and how these measures are working or not working, and whether checklists help or whether like trainings help, or this is kind of my constant area. So highly recommend FACT, especially AIES and Chi. Specifically, I'll give you a list of authors because I'm not going to make a list right now.
I'll write it down.
But well, they're really big I love this because there's like 10, 15 papers to read instead of 500.
All right.
So there's that as well. And then just from an inside story, the regulation is absolutely 1000% necessary. Human rights, not for the reason you just said. Human rights, absolutely fundamental, of course, but it's not going to work. In the best companies I've worked at, it's an attempt to tackle one particular technology or a high risk technology because it's always about making money. It's always about making money. And the business, this was the worst phrase I learned my first year in tech, the business gets to accept the risk. So, hey, there's a fairness problem here. It's really challenging. We would love to work on it with you. No, thank you. We're going to accept the risk. So there's way more facts I can give you to increase your anger. But I'd rather point you towards helpful sources to give you like user studies and STS and all that stuff.
That's helpful.
So
excellent. Thank you.
Bianca?
I'm like looking timing. Yeah, just quickly, brilliant work, everyone in this panel is fantastic. Like, and I love seeing the threads between the three. But Woody, I just wanted to say, because when you started to speak about the decimation of institutions, and then what you just said about relational, I think all of us need to contend with the fact that if the institutions are on the decline, and they are, we have to move to relation. We have to move to places where authority, moral authority, personal authority are the places to exert our power. So I think it's really important, because a lot of the time you get into the what instead, and like other people's work, I missed your name, Chinny's work, the same. It's like, even if we don't always do it, we have to at least open up that avenue. So it was nice to hear you bookend the institutional decline with the reference to the relational. So I think we have to take the responsibility on. So that's nicely coherent. So
excellent. Thank you so much. I appreciate that.
Thank you. Who's next? Katie? All right.
I know.
Watch you.
Hi, guys. Did you enjoy watching me walk from the back of the room? So much fun. Love the panel. Love the papers. Thank you, Teresa, for your wonderful comments. Threading them together. I thought it was so interesting. I have two things I wanted to talk about. The first one is Jen's topic about boundary objects. Jen introduced me to the topic of boundary objects 2 years ago in Halifax, and I've been obsessed with it ever since. I think it is such a useful metaphor for framing how we're thinking about AI problems. And when I was reading the draft, I was disappointed not to see more about the boundary objects, because I think that, like, when we identify these pinch points between disciplines, we can harness the concept of the boundary object to really help us elucidate what the challenges are from that transdisciplinary perspective. So how do we bring people from different fields together and get them talking the same language, which we're very bad at? We're trying to solve it. We're not doing that well. And so I wondered, even if, do we go one step further and even frame AI in that context as a boundary object? And then if we do, what advantage does that give us other than, as an STS topic introduced into a paper that people are reading? And so maybe there's like a regulatory sandbox, or there's a workshop, or there's something other than a toolkit or a list of, we definitely don't just want a list of principles that people are supposed to ignore when they're making design choices. But yeah, I want to see, that's what I don't know the answer. And I've been trying to figure it out myself, probably since that time we talked about this in Halifax. Yeah, it's just, those are some rambling thoughts, but if only Susan Lee Starr was here to help us, maybe she would know. Yeah.
Yeah, I think, yeah, so I would say I agree that I think I could, I could thread the concept through a bit more, and also discuss how the concept of boundary objects is doing a type of interoperability work. But one thing I would say is that I would push back a bit on the sense that we need to all be speaking the same language, because I think that's exactly the insight that the boundary object concept proposes, is that you have a term or a phenomenon that becomes a meeting point for people from different professional communities. So that could be AI. It could also be the concept of interoperability or risk even, right? And it's almost like a meeting point, but it's a place where people from different communities, or a mechanism that people from different communities use to try and communicate across those differences. So we don't need to be speaking all the same language. If anything, the thing that we need to be better at doing, I think, and I think one of the things that's great about this event is that we're doing it right now, is thinking about how to better cross communicate and to deepen our knowledge of our own kind of communities meaning making, if that makes sense. So what does regulation mean to lawyers, for example, or to legislators? What ought it mean to regulate AI, for example? How might interoperability and functioning AI systems look to be something different from the perspective of people who might be wanting to develop and distribute those systems? And with interoperability being that kind of touch point between those communities, but also many other communities as well, I think is the insight of boundary objects itself. In other words, it helps us understand how to be interdisciplinary in a deeper way, rather than just saying either we all have to speak the same language, or we're in this kind of family feud, like where you have the problems and we have the solutions type of thing. Like, I think that's where I see the richness of the concept, making contributions in work like this, and helping think through regulatory problems, but also helping think through the big kind of interdisciplinary or transdisciplinary or multidisciplinary, however you want to kind of categorize it, issues that we're grappling with today that are necessary, because tools like AI aren't just one thing. It's not just an object or a noun, it's a process, right? So yeah, but thanks for that.
I want to see that in the paper.
Yeah, for sure.
I
No,
love
it's all still, yeah, exactly. It's still evolving.
Is anyone else going to come up here? Okay, I'll ask another question.
Okay.
I'm already here. Woody, I want to talk about the rule of law.
Oh,
I
I knew
love
you
the
were gonna
rule.
say it.
Love the rule of law. And at the outset of the paper, you say that what you want to do is use a variety of methods to bring AI within the rule of law.
Mm.
But then you never really mention the rule of law again, other than to say that you want to bring it within the rule of law. So my question to you is, what do you mean by the rule of law when you say that, and what kind of approach to the rule of law do you want to take? And obviously, I care very much about the rule of law and have thought about this for way too long. But what I think is an interesting thing in rule of law scholarship is that there is such a divide between a formal and a substantive conception of the rule of law in terms of how scholars are characterizing the way that power adheres within society. And I think that there is something really interesting in a relational context about understanding a substantive conception of the rule of law and the sort of the conversation between people and their governments, and then the sort of quasi-governmental role that ends up being taken by tech companies. And I love so much what you just said about the vulnerability that we are entered into in those relationships with tech companies, right? Because the most vulnerable details of our lives become exposed by virtue of how we're going about our daily lives. And so what is it that in, the personal narratives that we develop that ends up being amplified in a way that is problematic to the rule of law, right? And the relationality element, I think, really helps us understand that.
Yeah.
Yeah.
That's a really great question. And this is going to be unsatisfactory because I think that we probably do have to unpack a little bit more what we mean by rule of law, which, as I see it, your question actually relates to Bianca's and maybe even Claire's about the role of relationships. So what we've been watching as tech oligarchs deploy AI to hollow out the administrative states in order to arbitrarily exert power, irrespective of rules, is that it feels like a slow motion train wreck, right? As we watch it sort of unfurl, and it's hard to know what to do about it. And so I think a lot about what is maybe the order of operations around all of this. Like, where do we even start to address this issue? And I really appreciate you thinking about sort of going where the power is. So one of the reasons that I've been drawn to the loyalty projects specifically over the past 10 years is that one of the things that I've come to really value is the role of narratives in shaping democratic will among people and the stories that we tell each other. And one of the most difficult things that I've struggled with AI regulation generally, so this the topic of this panel, is it feels often very formalistic sometimes, right? And so it's layered, it's bureaucratic, and I spend a lot of time talking to my dad about AI regulation, and my test is if my dad gets it, then maybe we're onto something, but if I lose him, then we're not there yet in terms of the narrative that's going to resonate. And so sometimes I talk to him about how it's important to have procedural checks on automated decision making, and he's like, yeah, and it's about as boring as like reading a CVS receipt, right? Like and so, but every single person in this room knows what it feels like to be betrayed. Every single person in this room knows what it feels like to be forced to trust someone in a relationship as part of whatever it is that we want to do in our daily lives, and to expose yourself, right? So a lot of people critique the loyalty approach because they say, well, we don't really trust Meta, we don't really trust Facebook, which is fair. But if you define trust as the willingness to make yourself vulnerable to the actions of others, then we do, in fact, by virtue of getting into a relationship with it. It's not much of a choice, right? Like, it's not it's not a true willingness, but we do it voluntarily. And so to me that resonates, right? And so one of the things that I really want to do is actually like my larger hope here. So if this feels like an appeal to legislatures, that's because this paper was born originally out of congressional testimony that I made. And so this is my attempt to try to get all of us to think about what the rules should be when we get so exposed, and then to use that collectively as a story that we tell ourselves and the people at the local level probably first, and then on the way up, about what rules should be in place to prevent that, which is sort of where I think that runs into rule of law. I don't know if that's responsive to your question, but I feel like that's great. What I'm thinking. Thank you.
Thank you so much for the conversation. This has been so much fun. I have a broad question. You're welcome to just say, no, I don't want to do this. And it's for anyone on the panel. It's something that I've been reflecting on a lot. So I'm just really curious to hear from 3 brilliant experts on what you think, or 4, Teresa, if you want to jump in. But I'm just curious, in thinking about AI governance, do we need to regulate AI because of something about AI? Or do we need to regulate AI because we're actually, we can be defined however you prefer, but we're actually shirking responsibility to ensure that everyone has what they need and to ensure that everyone has, the basic protections and strengths in society to live a happy and flourishing life. So is it that we're like AI is something special that needs regulation just like other things, or is it that society sometimes sucks and we're not going to deal with those deeper, harder problems? So instead, we're going to regulate at the edges, as was said in an earlier part of the conversation, and just deal with the potential for harm. Or feel free to say, Kristen, sit down.
I mean, I've got a lot of thoughts with this, but I've talked a lot, so I want to defer to my co-panelists. So you've asked a question, I suppose, that we've been struggling with since the very first We Robot, which is what's special about robots. And we're all the way back to, where's Katie? Law of the Horse stuff, right? I mean, the thing that I do run into consistently is the real difficulty in understanding how to meaningfully draw the line between using a technology to meaningfully help us with problems and using a technology because it is easier than actually drawing. And that's a lot of what I wanted us to get at. Unless we eventually start drawing bright lines about what it is that we want, a positive vision or a version of the good for whatever we want, tech companies are going to be more than happy to keep pitching something that may be beneficial to us, but it will not be made for us, right? If that makes sense, or in our best interests. And so we'll keep sort of devouring that all the way down. And but I do think that there probably is something significant. I mean, where's Ryan? He wrote a whole paper about this whole thing years ago about, what can we learn from the sort of lessons of cyber law? The affordances of AI are unique, if nothing else, in terms of scale, and the appealability, the way in which, any technology of sufficient complexity is virtually indistinguishable from magic, right? The way in which AI sort of is seductive. And so the seductiveness and scale of AI is probably unique in such a way that it creates risks that you might want a specific regulatory regime about it, because any technology that is sufficiently unique, it gets its own rule or maybe even its own regulatory agency. But that there, I'll defer to the experts other than me who've written about this.
Well, and I think just to, throw in there, and I won't take up too much more time, but whenever I think about deepfake, the use of deepfakes to create non-consensual intimate images. And there's a lot of calls, I think rightly, to deal with this through law, because this is a really harmful phenomenon. But ultimately, I find myself constantly coming back to what we actually have to deal with is misogyny. Like, why is it that people would feel the ability and right to create this image that they know is going to violate the autonomy and dignity of another person? But instead of dealing with misogyny, we're just going to regulate deepfakes. And I mean, it's something, but is it because it's AI or is it because we don't want to deal with misogyny? And or maybe it's a little bit of both. But I keep coming back to like, do we need AI regulation or do we need deeper conversations about hierarchies and power in society? Anyway, I'll leave it there.
Yeah, no, maybe I can just jump in there because I'm not, I mean, the way that I come at this conversation is thinking about particular examples. So I find that when we're talking about AI in kind of like as a catch-all term for so many different things, it becomes very difficult. And, you know, whether you want to make this like look back to the law of the horse conversations or look at Teresa's work on trying to figure out what's going on with the AI and Data Act as it was evolving and you were doing updates and thinking through all of the problems with that regulatory challenge in Canada. I think that, you know, it reveals how complicated it is when we're focusing on, when we're focusing but not focusing, I guess is what I mean, when we're trying to tackle something that has many forms. And for me, AI or not, I think that thinking about how, especially in the context of digital government, where there's tools, AI, but other tools as well, like spreadsheets and whatever else, that are fundamentally making it difficult to impossible for people to not just challenge how they've been treated, but to be heard in the first place. That's my concern. So whether you want to call that regulating AI or something else, I think that where I come into this problem is like, how do we ensure that that ability to contest and to be heard and to have the thing that you say be taken seriously, or have your side of the story and your evidence be taken seriously, is something that predates the conversations about regulating AI, but the urgency of that has been ramped up because AI and other tools make it that much harder to achieve. So
yeah, thank you. Let's keep talking over dinner.
Hi, Jesse Wu, technologist at the Policing Project at NYU Law School. First of all, I'll say that I actually like reading my CVS receipts because I want to know like what discounts I've gotten in exchange for my privacy. But so I have very separate comments, one for Christina and one for Woody. The first, Christina, this is a very kind of half-baked thought, but it occurred to me that the right to be forgotten is like maybe some sort of like precursor to algorithmic disgorgement, you know, as like this is sort of another way of getting at misuse of data and like giving people more remedy. I mean, right to be forgotten, it's like it's not a remedy, it's a sort of like different thing, but it's like what's something else in equity that we can give people to like vindicate their rights. I don't know what you want to do with that. Maybe probably nothing. And Woody, I'm going to recommend to you another chart, which is, you know, at various points in the article, you're citing to, you know, California, or Connecticut, and you have like bits and pieces of like, this is how, you know, whatever state is dealing with transparency and it's a half measure, but there's not much more elaboration. And so I think there are enough proposals and actually laws that have been passed at, you know, state and national governments that you have enough data that you could then list it out and say like, look, this is where we see the half measures that we've described coming up, and also, you know, here's how maybe we could move from these half measures to something that is more robust, more like a duty of loyalty or care, right? Because when we talked about this, I think when I was at Wyden's office, of like, okay, what is a duty of loyalty and care? And there are transparency aspects to it. There are other aspects to it. So how do you, like, you have the half measure? How do you move? Like, is there a way to move that to a full measure?
Yeah, that's great.
Yeah, no, definitely right to be forgotten has like some relationship with algorithmic disgorgement. Oh, sorry. Yeah, so right to be forgotten and algorithmic disgorgement, there's some connection to between those two things. I haven't quite fully figured out exactly how to explore that, but well taken.
So you're right, and if you think about it too deeply, I even have to concede that even duties of care, loyalty, and confidentiality are not enough in and of themselves. The main point of the paper, I guess, is just that we shouldn't stop there. That this is an ongoing. It's in the same way that data security is a process. Meaningful tech regulation is also an ongoing and never-ending process that must be constantly updated. But your point about how to make the jump is a really good one, and it's one that we've come close to a few times. So for those that aren't aware, the U.S. has been sort of fiddle-faddling around at the state level with various privacy regulations of variable quality. California's is good-ish. It contains a lot of half measures, but it does a lot of things really well. And then there are a couple of abysmal ones that are functionally just gifts to industry to let them do whatever they want to do and not upset their business model too much. And so we've come close a few times, and you're right, we should highlight that, but maybe it's worth talking about it. So there are a few rules around the design of information technologies that have come out that would sort of fall within the category of a more robust bright line prohibition. There are some bills right now pending in the state of Massachusetts that I'll be testifying in favor of in about 4 days, one of which would prohibit the outright sale of geolocation data, just flat out prohibit. There's a lot of rules that would prohibit targeted advertising to kids, period. And so we need more of those, right? And so you start to collect those together, and then you're really cooking with Crisco. But until you really start to stack those up one at a time, what happens is that inertia starts to run. Lawmakers get really nervous about new things. I've noticed, I've spent a lot of time talking with them. And you can say, hey, we should do a duty of loyalty. And you probably feel this very deeply. And we've had lots of conversations about this, which is the lawmakers are like, well, I don't like that. That's new. And who knows what would happen, right? There's all sorts of cascading uncertainties that come from that. But if you can start drawing lines to existing regulations and say, well, we already do this somewhere else and it works okay, right? Or we know the pitfalls to avoid where they do it somewhere else. And so we can avoid that this time. Then that's reassuring. It's like comforting. And the easiest change that we could make, and so I'll just make a pitch for the lowest hanging possible fruits that we could start for a duty of loyalty. I've said for years that all a state would have to do, Congress is not going to do it. I used to say Congress would do it, but they're not doing anything. And so all a state would have to do is modify its unfair and deceptive trade practices laws to include a prohibition on abusive trade practices. And abusive trade practices are those that leverage people's own limitations against them. And so it's a betrayal. It is a betrayal of people's vulnerability. The CFPB already has this authority. And various state laws are sort of poking around with it. And so that would be a very easy jump. And then from there, you could then start to the key is to get the overarching duty, but you could also back into it by implementing various different pieces of a loyalty approach. And then you wake up one morning and you're like, well, we already have the smaller pieces. We could just sort of put a big umbrella around it. Yeah, so that's but don't tell anyone. That's my move.
Yeah. I'll say it's a little easier to be bold when you work for Chris Segoyan.
Oh, right. That's true. Yeah, that's fair. That's fair.
So are there any last questions? Does anyone on the panel have a question for anyone else on the panel or any final words?
I just have a sort of a general reflection. I appreciated your way of trying to tether some of these things together. What do you think that the sort of right approach would be thinking about remedies? And so thinking about sort of interoperability of remedies is one of the things that comes up a lot. And then thinking about sort of disgorgement, a lot of discussion talks about what the rules should be. but we haven't talked a lot about where it cashes out, except that, your paper does a really interesting job of that. So would you suggest anything to complement disgorgement as part of that? Like is there anything that rides alongside that from a consumer protection perspective, or would you view that remedy differently in different contexts?
So I think part of what I try to do in my paper is I think, as much as I like point out all the shortfalls of algorithmic disgorgement, I do think it has a place in certain like specific instances, right? Like in like Cambridge Analytica, I think it was the right remedy to go for. So I think it's really about just like when are you using that remedy and like how does that make sense in that specific context, right? And I think I do think in especially in the context of AI, like monitor like just like money damages and also just like traditional injunction, like just the tools that we've had with us for a long time really could go a long way as long as we're like smart about how we use them. And I think a lot of, obviously in the US context, like with a lot of like the privacy harms, algorithmic harms, there's some standing challenges and all of that. So like whether we're going to get to remedies at all, like whether we'll even get there is a big question. But yeah, I think just like a lot of like things that we've had for a long time, I think can be used to great effect.
All right. Well, thank you to our terrific panelists for their papers and their commentary, and to a very engaged audience. Thanks, everybody.
Thank you so much. We've got coffee and snacks out in the hallway. If you can be back for 3:15, we'll have our last panel of the day. And then we've got our poster session downstairs after that. Thank you.
Really, just one more. Oh, that's right. Yeah. Well, they were interesting papers.
Yeah. It's so useful to have your perspective as well, especially given all, as you were kind of doing your own analysis of what was happening with the federal legislation. I was kind of dropping in when you were posting on your blog and things like that. Yeah.
Yeah. I was thinking in the course of the discussion whether you are more generous to the concept of interoperability than I am, and which was interesting to me, because then I thought about it. And maybe I'm just cynical about everything these days, but